The Supreme Court just delivered an 8-1 emergency ruling that sent Missouri's Second Amendment Preservation Act into a tailspin. Gun owners across the country thought SAPA would be the blueprint for state resistance. But now, the highest court in the land has put the brakes on that revolution. So, what does this mean for the future of state-level pushback against federal gun laws? In this video, we'll talk about Missouri's bold stand against Washington, why law enforcement turned against the bill, and how the Supreme Court's decision could reshape 10th Amendment fights across the country. We'll also dig into the intense debate inside state legislatures, the national ripple effect of SAPA copycat bills, and what Missouri is doing now to salvage its two-way firewall. There's a plot twist involving the Trump administration, a former state attorney general now serving as solicitor general, and a Supreme Court docket full of other gun rights battles waiting to explode. Missouri's Second Amendment Preservation Act started as a simple but audacious idea. If Washington keeps inventing new gun restrictions, Missouri cops will sit the enforcement game out. Passed in 2021, the statute barred state and local officers from helping federal agents with anything the legislature believed violated the right to keep and bear arms. It even let private citizens sue a department for $50,000 each time an officer ignored that firewall. Gun owners cheered because it felt like real resistance after years of watching the bureaucracy chip away at pistol braces, bump stocks, and magazine sizes. Opponents warned that cutting off cooperation would leave investigators scrambling when a trafficked Glock showed up at a homicide scene. The real fireworks began when the Biden Justice Department, joined by St. Louis and Jackson counties, marched into federal court and argued that Missouri had trampled the Supremacy Clause. The first judge to hear the case agreed with Washington. He ruled that threatening huge penalties chilled officers from doing the bare minimum required by federal firearms laws, and he blocked the act. Missouri appealed to the Eighth Circuit, asked for a stay so the statute could remain in force, and was turned down. That refusal set the stage for an emergency sprint to the Supreme Court. Gun rights advocates thought the same court that handed down Bruin would at least pause the lower court order. Instead, 8 justices declined. Only Justice Thomas said Missouri deserved a stay. With one paragraph on an order sheet, the court jolted everyone who had assumed a reliable conservative majority would reflexively side with a state pushing back against Washington. For Missouri's police chiefs, the denial meant business as usual could resume. Joint task forces that had paused since SAPA's passage powered their laptops back on. Ballistic evidence flowed again to the National Integrated Ballistic Information Network. The chilling effect disappeared overnight because the lower court's injunction roared back to life. That practical relief, though, came with a political price. Grassroots 2A supporters suddenly felt abandoned. Many asked if the court's silence signaled a new unwillingness to defend states' rights when firearms are involved. Comment threads lit up with speculation that the emergency standard was simply too high or that the justices wanted a cleaner vehicle for resolving the question. Whatever the reason, momentum inside the Missouri Capitol hardly slowed. Representative Bill Hardwick introduced a revised Preservation Act. Gone were declarations that federal gun regulations were null and void in the state. Instead, the bill told Missouri officers they shall not enforce those rules. Hardwick insisted the tweak preserved the law's backbone without poking the Supremacy Clause bare. The measure sailed through the House 151. That margin hid growing cracks. Several Republicans, pressed by district sheriffs and county attorneys, crossed party lines and voted no. Chiefs from Columbia, Branson, Rolla, and Ellisville testified in the Senate that even the new draft would expose departments to punishing lawsuits, wreck recruiting by banning the hiring of former federal agents, and leave detectives second-guessing every call for cooperation. Ellisville's Steve Lewis told senators that if a felon is caught with a rifle, his officers need fast help from the ATF, not a civil subpoena. Insurance carriers quietly warned city managers that premiums could jump again if SAPA 2.0 became law because every lawsuit clause spelled heightened risk. While the legislature wrangled, Missouri petitioned the Supreme Court for full review. The brief asked whether courts may strike down a state's exercise of 10th Amendment authority based on the legislature's motives. It argued that refusing manpower is passive, not obstructionist, that compliance with state law is not enforcement of federal law, and that forcing states to hide their constitutional doubts behind bland policy language twists representative government. Missouri drew on Prince v's United States, The 1997 decision that said Washington can't commandeer local officers for background checks and claimed SAPA merely extends the same refusal into modern gun control terrain. The timing of that petition created an unusual subplot. The new Trump administration now controlled the Justice Department, yet the Solicitor General had defended SAPA when he served as Missouri's Attorney General. Suddenly, the federal government had to decide whether to keep fighting the law it had sued months earlier. Observers wondered if the DOJ would switch sides, file a narrower brief, or seek more extensions to avoid taking any stand before the court acted. Every delay added suspense because the docket already brimmed with other firearms cases, a challenge to Rhode Island's magazine cap, lawsuits over California's semi-automatic rifle rules, and appeals contesting New York's post-brew and carry hurdles. If the court granted Missouri's petition, it would be tackling not only the individual right to arms, but the broader divide between state sovereignty and federal supremacy. In the meantime, real-world policing remained entangled in uncertainty. Chiefs remembered the freeze-out from 2021 and braced for a repeat if SAPA 2.0 cleared the Senate. During the earlier stint, the Missouri State Highway Patrol pulled out of every joint ATF task force. E-trace submissions plunged. Leads on interstate straw purchasing rings dried up because local detectives feared a misstep would invite a ruinous civil payout. Homicide victims' families called city halls asking why ballistic matches went nowhere. Officers complained that paperwork once routine now required legal vetting. The coalition against the new bill insisted those nightmares would return, pointing to the unchanged lawsuit provision as the ticking time bomb that would scare departments away from any federal cooperation. Gun rights activists answered that violent felons already ignore Washington's rules. They argued that funneling state manpower into federal gun raids does nothing but help bureaucrats build momentum for the next round of regulations. They cited examples where ATF letters transformed a pistol brace into an NFA item overnight and insisted cooperation only enables that mission creep. But to them, SAPA does not hamstring public safety. It erects a principled line that forces Congress to enforce its own mandates without conscripting local agencies. If Washington wants to roll trucks on felons, it can hire more U.S. Marshals and leave sheriffs free to focus on actual community threats. That philosophical clash traveled well beyond Missouri's borders. Activist Aaron Dorr rallied supporters in Iowa, Wyoming, and Kansas to demand copycat bills. Wyoming's legislature sent one to Governor Mark Gordon, who vetoed it after nearly every sheriff in the state begged him to. Kansas lawmakers backed off under similar pressure. Iowa's version never left committee. Yet the energy refuses to dissipate because the underlying grievance is bigger than one statute. Many gun owners see a federal apparatus that invents new firearm definitions through rulemaking and then leans on local officers to round up the non-compliant. If states cannot say no, what guardrail remains? Federal agencies stress that joint efforts are essential. The ATF's National Tracing Center links crime scene guns to original purchasers in minutes. Task forces smash trafficking pipelines that ship pistols from low-regulation states to big city gangs. The FBI's Annex section depends on county clerks uploading dispositions, so background checks are accurate. Strip away local cooperation and these webs lose strands, giving bad actors room to maneuver. For chiefs tasked with lowering the body count, those tools matter more than any philosophical contest. Chief Lewis paints a grim scenario where detectives holding a suspect with a firearm must decide between cooperating with the ATF or gambling on state resources alone. He fears lawsuits will steer departments toward the safer legal path, do nothing that smells federal. The Supreme Court could settle that tension by clarifying how far a state may go in declining assistance. It might conclude that Prince already answered the question and that SAPA's penalties merely restate a right to say no. It might rule that civil damages cross a constitutional line by effectively nullifying federal law. Or it could deny review, leaving the Eighth Circuit's opinion to chill every future preservation bill. Court watchers look for signals. Relists often mean a pending concurrence, or dissent is circulating, and a sudden grant at the term's end could foreshadow a blockbuster next June. If the court accepts the case, oral arguments would unfold just as campaign season peaks, guaranteeing national debate about state sovereignty, gun rights, and federal reach. Back in Jefferson City, senators tinker with amendments. Though critics say the heart of the bill, civil suits, remains untouched. Chiefs lobby for an explicit safe harbor clause shielding officers who act on good faith requests for help in violent felon prosecutions. They know that without such clarity, line officers will hesitate. County commissioners ask insurers for projections. Some carriers already hint that rates could double for agencies that remain exposed. Hardwick contends those fears are overblown because the law targets willful collaboration, not incidental data sharing. He insists bad actors who exploit federal databases to harass gun owners should worry, not honest detectives stopping murderers. Each side accuses the other of misreading the text, yet no compromise emerges. Outside the Capitol, Missouri's voters split along familiar lines. Rural residents applaud SAPA as a shield against coastal lawmakers who lump their deer rifles with battlefield carbines. Suburban swing districts hear police chiefs on talk radio recount task force successes and wonder if cutting those ties invites more crime. In urban cores, the debate intersects with concerns about rising shootings and questions why state politicians would limit tools that trace illegal guns flowing into neighborhoods. The divide illustrates how firearms policy rarely rests on abstract rights alone. It lands in streets, patrol cars, and court dockets. Should the court eventually uphold a revised SAPA, the victory will embolden legislatures everywhere. We could see a second wave of bills, this time drafted with the court's roadmap, shielding officers from civil penalties if they decline cooperation while still passing constitutional muster. States that already embrace permitless carry, campus carry, and robust self-defense statutes will likely move first. Blue states will fire lawsuits claiming the patchwork undermines national safety. The debate will cycle again, but with clear Supreme Court language guiding every brief. If instead the court buries SAPA, lawmakers may pivot to narrower tactics, refusing to spend state funds on certain ATF initiatives, mandating local warrants before accessing state databases, or layering procedural hurdles that slow rather than bar cooperation. Regardless of the eventual ruling, SAPA's journey has already reshaped Second Amendment politics. It turned a spotlight on the often ignored partnership between small-town deputies and federal agents. It forced honest conversation about the cost of civil penalties and the perils of litigating law enforcement decisions. It pushed gun rights advocates to think in terms of federalism, not just personal possession, and it reminded chiefs that public safety missions live or die by legal clarity. The drama now rests with 9 justices and a Solicitor General weighing his past defense of SAPA against his new role. One ruling could wake dormant 10th Amendment power, another could lock states into permanent cooperation with federal gun control. Meanwhile, Missouri's Senate deliberates, insurance actuaries crunch numbers, and detectives quietly hope whatever the law becomes. It will tell them with certainty when they may tap federal help and when they must stand alone. Until that clarity arrives, the preservation fight continues, a test of how far a republic that prizes both local autonomy and national supremacy can stretch before something finally gives. And that's it for this video. Missouri's SAPA law dared to defy Washington, but with the Supreme Court's 8-1 decision, the battle just got far more complicated. Should states be allowed to reject federal enforcement if they believe it violates the Second Amendment? Is Missouri's legal strategy the model for others, or a cautionary tale? Drop your thoughts in the comments. Then hit like, share, subscribe, and click the bell so you never miss an update on the two-way war playing out across America.